I'd like to call the Fiscal Committee to order at 10 a.m. This is a special meeting. We have one item on the agenda, and that is we made several suggestions on the YDC settlement process, and I'd like to call General Formella forward and ask him to please identify the things that he's changed, and we'll go from there. So if I could, General Formella.
Well, thank you and good morning, Madam Chair, members of the committee. For the record, John Formella, Attorney General, and appreciate the opportunity to be back before you again this morning. So last time we were here about a month ago, I went through in quite a bit of detail the documents before you that set up the claims process and settlement guidelines for the YDC Settlement Fund. I thought what would be helpful this morning is to walk through the changes we've made after our discussion with the committee on August 10th, and also after our discussions that we've had with Claimants Counsel since the last meeting. Most of the documents are the same, but we've made some key changes that I want to walk through, and then I'm happy to take questions either on the changes or, of course, on any of the substance of the documents. So what we did after the last meeting, we went back and we first cataloged all of the comments we got from the committee, just to try to make sure that we had captured all of the feedback that you all had provided to us. And we also have had some pretty extensive conversations with Claimants Counsel, not specifically with Nixon Peabody. They've generally chosen not to engage in the process, but we have had some very productive conversations with other Claimants Counsel since the last meeting. And I think that we have reached a good compromise on some changes. And I think that, I feel comfortable sitting here today telling you that we have an indication both from Claimants Counsel who have written letters to the committee and also other Claimants Counsel who may not have written letters but have indicated that they have clients who they believe will participate in this process. I think the general feedback from many of the Claimants Counsel out there is that this process is not perfect, and we of course would never claim it would be, but we believe that many Claimants Counsel now feel that this will be workable for many clients who are out there. So that is generally, I think, where we sit here today, but I will walk through some of the specific changes we've made. Actually, before I do that, one thing I also want to add is that we've had productive discussions with Claimants Counsel about who the administrator might be. And while, we're not prepared to name names publicly today, I think that we have a good understanding between our office and Claimants Counsel on who would make a good administrator. And I'm confident that if this process is approved, we will be able to come to agreement on who the administrator will be very quickly. And I think that will be important as this process moves forward if it gets approved, because once this committee approves this process, if the committee approves the process, and once the administrator is appointed, the administrator will sort of take control of this process, and it will be the administrator who can come back to request changes from the committee. I think that's an important thing to keep in mind as we walk through the documents today, because the administrator will be, I think, seen by many claimants as a more neutral party. And so the fact that the administrator will sort of take control of this process and take control of requesting future changes should give some comfort to those who may still feel that there are some tweaks that can be made as we go forward and as we see how this process is implemented. So with that, I'll walk through the changes we've made since the last meeting. The first overall change we made, based on, I think, feedback from Representative Emmerich, was to split the documents into separate documents. It was always our intention for these documents to be presented to claimants as separate documents, but I think presenting them to the committee as separate documents is helpful in seeing what this looks like if each document stands on its own. So last time we had 3 documents that were packaged together. You now have 4 documents in front of you because we added a notice document based on feedback that we got at the last meeting. I'll walk through that when I get to it, but I thought it would be most helpful to walk through the documents in order. So the first document that you have in front of you is FIS 22-307. This, as we discussed last time, is the claims process document. As we talked about at the last meeting, the claims process document is really meant to be sort of the governing document for the settlement process. It's the rules of the road, if you will. So the claimant themselves will not have to go through and digest the claims process document. The claims process document is really for the administrator and the attorneys who are involved, because it's the rules, or put another way, the law that will govern the settlement process when and if it's approved. So we made a couple changes to this document, not anything major because most of the feedback was on other documents. But the first change that we made based on feedback at the last meeting is at the top of page 10. This is the section of the process regarding notice to claimants of what their options are after they get a proposed award from the AG designee. If the claimant does not agree with the AG designee's position or proposal, or actually I should say when the claimant gets the AG designee's position or proposal, the claimant has the option of accepting that position, of requesting that the process go to the administrator so that a proceeding be scheduled in front of the administrator. And then the third option the claimant has is to withdraw their claim from further processing. And we just wanted to make clear that if that happens, the claimant can then proceed with any pending litigation. The reason this clarification was important is that if a claimant enters this process and they've already filed a lawsuit, they would have been required to sign an agreement to stay that lawsuit while they go through this process. So we wanted to make clear that as part of option 3, as part of withdrawing their claim from this process, they can continue with their litigation. So we just clarified that at the top of page 10. Another clarification we made in the claims process document, and we made this clarification throughout the various documents, is found on page 19. And this is where we defined former YDC resident. We just wanted to make clear that a current resident is considered a former YDC resident for purposes of the statute, because the statute defines a YDC resident as someone who resided at YDC at any time. So for example, if say a current YDC resident on a Tuesday claims they suffered abuse either earlier that day or the day before, they fall into this definition, and so they could use this process. And then there's one additional change we made. This was based on discussion with claimants counsel, and I apologize I went out of order, but this change is on page 16. It's about the middle of page 16, section 27. This is the language that deals with attorney's fees and costs. We wanted to just simplify this language a bit. The statute provides that the top attorney fee award can be no more than 33.3%. And rather than have a number of factors that the administrator weighs, we figured it would be easier to note that the administrator can take into account a fee agreement that a claimant might have with their lawyer, and that the administrator should just review an attorney fee request to ensure that it complies with New Hampshire Rule of Professional Conduct 1.5, because that rule already governs attorneys on what fee they might take, especially if it's a contingency fee, and that rule is meant to ensure that fees are reasonable. So we thought it would make more sense to tie that type of review to Rule 1.5 than to try to have some, different standard that might be separate from that or have factors that are separate from that. So those are the changes we made in the claims process document. Again, these were based on feedback from the committee and also feedback from claimants counsel. The next document that you have in front of you is a new document, and it's fairly short. But this is FIS 22-308. And this is an additional document we added regarding notice. At the last meeting of the Fiscal Committee, and based on conversations with claimants counsel, we received feedback that we really needed to beef up the notice section a bit to make sure that we were going to be doing everything we can, that the administrator would do everything they can to provide notice to any potential claimants that might be out there. So what this document does is provide guidance to the administrator on providing notice to potential claimants. And it covers mechanisms that were already covered in the statute. So the mechanisms that were already covered in the statute were notice in newspapers, notice on social media, postings at correctional facilities, press releases, and website postings. And based on discussions with claimants counsel and based on discussions at the last Fiscal Committee meeting, we talked about how it would also be helpful to post notice in courthouses and in clerks' offices, in community mental health centers, and where we can, in private offices of private mental health practitioners. So the idea being that we want to try to cover any potential place where someone who might be a potential claimant that would go through this process might go or might pass through. So we expect that the administrator will also, when that person is appointed, will take a look at this and frankly may come up with even additional ideas of where we would post notice. But we wanted to give them as much guidance as we could, so we added this document. This document also helps to just sort of highlight how important notice is, because at the end of the day, we could have the best process in the world, and if people don't know about it, if potential claimants don't know about it, it's not going to be helpful to them. We also recognize that, after so many years, and when we're dealing with such a large number of potential claimants, that we can't make any assumptions about the current circumstances of a potential claimant who's out there. Someone could find themselves at this point in any number of life circumstances, and we want to take that into account when we're trying to make sure we cover all our bases with providing notice. So that is document FIS 22-308.
Representative Edwards, you have a question?
Yes, ma'am. Thank you. Mr. Attorney General, what would be the process in a few years if somebody who had wanted to file a claim or had an argument that they should file a claim, if they find these notices inadequate, is this appealable? Is this something that they can come back and say that we were negligent on? This is probably pretty comprehensive, but I'm just curious what their recourse and what the outstanding risk would be to the state.
The statute that was passed provides a deadline of December 31st, 2024. I think that if someone didn't get the notice, their recourse really would be to come back and make and the deadline had passed. I think their recourse would be to make an appeal to the legislature to extend the deadline, or to bring their claim in court. I don't see a lot of exposure for the state on a claim that we didn't do a good enough job providing notice of what's essentially an alternative dispute resolution process. But it will absolutely be our goal to make the notice so widespread that if someone doesn't file a claim, it won't be because they didn't know about it. It would be because they decided not to file a claim. So the next document you have in front of you again now as a separate document, is FIS 22-309. This document is the guidelines for valuing claims. So in this document, we made a couple of significant changes based on our discussions with claimants' counsel. And I believe that these changes will represent a good compromise on how to value these claims. And these changes are sort of key, or a key piece of getting a number of these claimants' counsel on board with feeling that this process would work for many of their clients. So the first change is one I've already mentioned, but I'll just note that it also appears in the guidelines, and it appears in a couple different places. But this, again, is the definition of former YDC resident. So there are a couple of places in this document on pages 3 and 7 specifically that we, again, are just clarifying that a current resident who might be in YDC now or in the Sununu, what's now the Sununu Center now, would be considered a former YDC resident for purposes of the statute and purposes of this process. The next change you'll see on page 9. And this is near the top of page 9, but this is in the frequency multiplier table. In the first draft of this process that we brought before you, you'll recall that sort of the range, if you will, of number of incidents spanned all the way from 1 to 25 or more. And the multiplier went from 1 to 15. Based on discussion that we had at the last committee meeting and discussions we had with claimants' counsel, we've had a lot of exchange about the need to recognize that, for someone who suffers sexual or physical abuse, there may be a difference between one incident and 2 incidents, but once you get beyond 1, based on the harm and the trauma that you suffer, it really is necessary to not require so many incidents in order to get to the top of the range as far as the value of settlements goes. Given that the cap in this process is 1.5 million, I think everyone recognized that it's also important to have some recognition that those who may have suffered more incidents of abuse should get more compensation to a point than someone who suffered less incidents of abuse. So those were the two considerations we were trying to balance when coming up with the frequency multiplier table. When we were initially discussing this process before we even brought the first draft to you, we had a proposal from certain claimants' counsel that the frequency multiplier table go from only 1 to 8. So with 1 incident, you got a certain multiplier. Once you hit 3 incidents, you got the next highest multiplier. And then once you, that it only required 8 to get to the highest multiplier. We had put that out to sort of the full universe of claimants' counsel, and we didn't get feedback one way or another on that at the time. And so that was why we decided to bring our original proposal to you, which had the wider range. Based on the committee's feedback and based on the discussions we've had with claimants' counsel since, I think we have arrived at a good compromise that I think many claimants' counsel generally support and that many claimants' counsel see, and it makes them feel that this is a process that will work for many of their clients. And that is the frequency multiplier you see before you now. It spans from 1 incident is the bottom category. The top category is 10 or more. And the multipliers step up 1, 3, 7, and 12. So I think what this does is balance. It recognizes the fact that values of settlement should step up quicker based on a smaller number of incidents, but that there also should be some range between 1 incident and 10 or more, so that we're giving we're recognizing from a value perspective the fact that, say 7 or 8 incidents are more harmful than 1 or 2. As I've said repeatedly throughout this process, there really is no perfect way to do something like this. There's no amount of money that really compensates someone for experiencing sexual or physical abuse. And there's never going to be a perfect way at which you can arrive at a value or a way to value compensation that someone should receive for that type of harm. What we've tried to do with this is put a lot of thought into it, have a lot of conversations, think about all the considerations at play, and arrive at a compromise that does the best we can to balance the different considerations that are there. And I think this table does it. And I think that is reflected in the letters that you will have received from Claimants Counsel. And it's reflected in conversations we've had with other Claimants Counsel who, while they were not comfortable sending a public letter, they indicated that their clients, or many of their clients, they thought would participate in this process. So that's probably the most major change made in the valuation guidelines. The other thing you'll notice is that we no longer have 2 separate tables for sexual abuse and physical abuse. This revised frequency multiplier table applies to both sexual abuse and physical abuse. A couple of other changes we've made when it comes to valuing settlements were based, again, on discussions with Claimants Counsel. The first one I'll point out, well, they're both on page 9, but the first one I'll point out is down in table 4. These are the aggravating factors for claims for sexual abuse. And this first change is on the value of the aggravating factor associated with photographs or video recordings that might have been taken during an incident of abuse. As we've talked about this with Claimants Counsel, we have talked about the fact that for someone who suffers abuse, the fact that photos or video might have been taken is something that can sort of cause continuous trauma, because if you have suffered abuse, even if it's years and years ago, if you have reason to think that there are photos or videos that exist of that abuse, you live in constant fear that those photos or videos could resurface, and that sort of causes a continuous trauma, continuous harm from the abuse you've suffered, even if it's decades ago. So we've increased this aggravating factor from $50,000 to $125,000. The other change we made here is in the aggravating factor that is associated with the duration of abuse, so the length of time during which someone might have suffered abuse. This is found on page 10. It's near the top of the page. But what we've done in the original proposal, the course of conduct would have had to continue for 24 months for this aggravating factor to come into play. We've reduced that period from 24 months to 12 months based on discussions with Claimants Counsel, and we've increased the multiplier from 0.25 to 0.5. So again, I think this is another change that came out of what were very thoughtful and productive conversations with Claimants Counsel about different things we needed to recognize when it comes to valuation of these settlement amounts. The last significant change that I'll point out is on page 12, a little over halfway down the page. But this was the section related to issues of credibility. In the last version of this document, we had a sentence that said that, statements made by a claimant made under oath and notarized we would presume them to be credible unless shown otherwise. With that statement, we were trying to reflect that, we would not assume any claimant who comes to this process is not telling the truth. We would treat every claimant with respect and dignity. But based on discussions with the committee and looking back at the legislative history, we ultimately determined that we did not need to have that sentence in there and really should not have it in there because it would lead to a concern that we were, say, shifting the burden of proof from the claimant to the state. And, also in looking back at the legislative history, there were specific discussions about that issue, and the language regarding treating every claimant with respect and dignity was put in there, I think, specifically as a way to reflect that value without having language that sounded like it would be burden shifting. And so we ultimately determined, based on feedback from the committee and looking back at the legislative history, that sentence really should come out. So we've pulled that sentence out of this section. I think, these documents still absolutely reflect the value that we will treat every claimant that comes to this process with respect, with dignity. We'll listen to their stories, take in their information, certainly not assume anyone is not telling the truth. But at the same time, it's important not to have language in there that looks like it's a burden, a language that would be shifting the burden of proof. So that is the kind of the final major change that we made to the settlement guidelines. The last document that you have in front of you is FIS 22-310. And this is the claim packet, which includes the claim form and the worksheet. We've tried to make a number of changes here to make this more accessible to victims / claimants, and to make it more user-friendly, and to make it even clearer that we recognize that any victim or claimant will come to this process in a different situation, in different circumstances, with perhaps different capacity to really grapple with a document that, no matter how we try to simplify it, is going to be somewhat complicated just because we are dealing with frankly complicated issues. But we have tried to make it as simple as we can. The first thing we've done, based on feedback at the last committee meeting, was just to improve the line spacing. So where you'll just notice where that there's a section for writing in content, we've tried to improve that line spacing. I do think that it's important to remember that in many cases someone might just attach additional sheets, so they may not rely on what's here to write in what they want to write in. They may have a separate piece of paper where they write additional information, but we've at least tried to widen that spacing out so it looks a little more, it just is easier to get the writing in. We have also, throughout this document, based on feedback from the committee, and again, we've had discussions about the deadline for submitting claims, we've just tried to add and highlight the notice about what the deadline is to submit your claim in various places. So you'll see that throughout this document. I won't turn to every place where that appears, but we've tried to put a black box around it, tried to put it in more places so that it is very clear what the deadline is. It's December 31st, 2024. At the last committee meeting and in discussions with claimants counsel and our victim witness advocates, victim witness specialists, we had a lot of discussion about this issue of what is required versus what is optional. And ultimately, the way we've tried to address that here is to set this up so that no information is required, that we make it clear to claimants that the more information they submit, the better, that certain information may eventually be required. Obviously, we will need to know someone's name, we'll need to have sufficient identifying information, but that a claimant should just put in to this form as much information as they can, and that not only is assistance available, but also once a form is submitted, if the administrator determines that additional information is needed, the administrator will contact the claimant and work to get that information. What we've really done here is put this in the hands of the administrator, who will be the third party neutral. It will ultimately be up to the administrator to take a look at what's submitted and make determinations as to what additional information is needed to process these claims. I think that is a good way to balance the need to collect information with the need to make this accessible to victims. Ultimately, in my mind, it is actually helpful to a claimant or a victim to ask for certain information, even if we're not going to require it. Because what we're doing when we do that is that we're providing sort of the guideposts and the direction as to what information will make their claim stronger, will strengthen their ability to get a higher award. I think that asking for that information is I would submit, is helpful to claimants and actually makes this victim friendly. But we do recognize that we need to provide a fair amount of flexibility in what we would require to be submitted. And so I think what we've achieved here by making this information generally optional is we have given sort of some guideposts and a roadmap for a claimant on what is helpful and what will help them strengthen their claim without requiring them to submit it to have their claim processed. And so it gives the claimant options as to how much they want to bring forward, and it puts the discretion in the hands of the administrator, who will be the neutral party in this process, to determine, what might be missing and what they need to go back and ask for. So that's reflected in a couple different places in this document. You first see it on page 2, where we take out any reference to required information and just ask that a claimant do their best to provide as much requested information as they can. And that can also be seen on page 4, where even for some of the required identifying information, we note that might eventually be required, but it's not going to be required in order for a claim to be taken in and for the review to begin and for the administrator to take a look at it and begin the process of reaching back out to the claimant if necessary to collect identifying information. Again, there are some basic things that we will need eventually for a claimant. If they submit a claim and money is going to be paid out on that claim, we'll need to make sure that we know who that person is. We'll need to make sure that we can confirm it. But we want to make this as user-friendly as possible, and we want to make it clear that this process will be set up in such a way that everything possible will be done to assist someone in providing the necessary information. So giving them guidance on what information is helpful and also giving them assistance on collecting it. We certainly don't want the need to collect information to be set up as a burden or an obstacle. So those are really, and these changes just kind of appear throughout the packet, but those are really the major change made to the claim packet, is setting it up so that the information is optional. In the worksheet, which again is an optional tool for a claimant, I'll just note that we have, again, made the changes necessary to align with the fact that the multiplier is now going to look different, and made the changes necessary to align with the fact that the aggravating factor for photographs or video is now up to $125,000, and the duration, the change to sort of the aggravating factor for the conduct occurring over a period of time we've reduced that time period from 24 months to 12 months and increased the multiplier from 0.25 to 0.5. You'll see those two changes on pages 8 and 9 of the claim worksheet. So again, they're just identical changes they're identical to the same changes we made in the valuation guidelines. in addition to or I should just say, just to kind of sum up with the changes to these documents, I would say, there aren't a large number of changes to what we presented last time, but I think the changes that were made were some very key changes. The multiplier table was a very, I think, fundamental change made to the valuation guidelines that I think addressed perhaps the most significant concern we heard from many claimants counsel out there regarding requiring less incidents to get to the top value. And then shifting the packet and the worksheet from required information to information that's all optional, I think really goes a long way to addressing the concern that the claim form and the worksheet is too complicated. Again, there was no way to really put together the claim packet and the form without having a number of questions and requests for information. And the reason, again, for that is that by asking those questions and showing claimants what information will be helpful to them, we're actually giving them a roadmap to what can lead them to a potentially higher settlement value. But by making that optional, we're not requiring that all of that information be submitted, and we're not ending up in a situation where having to answer a large number of questions, submit a large number of information at the outset, ends up discouraging someone from participating in the process or coming into the process in the first place. So I think the changes we've made here, again, while they're not a large number of changes, they're significant changes that make this process both more accessible and also address the most fundamental concerns I think we heard from many claimants counsel about how we're valuing these claims. We also had submitted to you a letter from the Department of Corrections, and Commissioner Hanks was kind enough to take the time to appear before you today to answer questions with regard to how a resident at one of our facilities might interact with this process. So the Department of Corrections did submit a letter to you that just outlined the process they would use for providing notice of something like this to residents. And that letter discusses the tablet method. Residents do have access to tablets and also closed circuit television. And that letter noted that notice could be published even on a weekly, notice of this process could be published even on a weekly basis. And that the Department of Corrections would work with the administrator once that person is appointed on the language of that notice. The Department of Corrections letter also noted that residents have access to facility libraries, and it's through those facilities that they usually use those facilities to contact counsel. And the department noted in their letter that they could make the list of available attorneys or the published list of attorneys, they could make that available through the tablet system. The department also noted in their letter that residents who litigate have access to notaries through assigned counselors and case managers, and that notary services would continue to be available to residents, and that residents have access to a phone system. The department did note that the administrator would need to be able to accept collect calls, but I'm sure we can work with the administrator to make that happen. The one thing the department did note is that residents do not have access to the internet, and that's something that would not change with this process. But I think, as the department notes in their letter, there are a number of other tools that can be made available to ensure that residents will have access to getting their claim forms in. And we may be able to work with the Department of Corrections to find some way to allow some type of electronic interaction with this process, but we'd have to have further discussion about that with the department, and we'd have to, of course, balance the need to make this accessible to residents while not making any fundamental changes to current restrictions that the Department of Corrections has in place, because I'm confident that there are very good reasons for why the Department of Corrections has things set up the way they have it currently set up. So the Commissioner of Corrections is here again to answer any further questions on that if the committee has questions, but I just wanted to outline what the department had provided in their letter. In addition to the changes I've just noted here, we did, also try to go through these documents and make any typographical errors. I'm hoping we caught all of them. I think there were a couple that we missed that Representative Lynn has already pointed out, but we will make sure that those are, if the committee would permit us to make only typo type corrections, not anything else. So we have not asked for permission to make, non-substantive changes or anything like that. I would propose that the committee give the Department of Justice the authority only to make what would be typographical corrections, so that we can address any typos that we might find. But we can also bootstrap that with the administrator. If the administrator finds any more significant tweaks that are needed, the administrator, once that person is appointed, will have the authority to come back to fiscal and ask for those changes. And as I mentioned earlier, I think that the administrator coming back to ask for those changes probably gives even more comfort to claimants, because the administrator will be the objective third party in this process. With that, those are the changes we've made. I just want to say I really appreciate the conversation we had at the last meeting. I think we got a lot of good feedback. We had some really good discussion on how to make this process better. I really appreciate the conversations we've had with Claimants Counsel, especially since the last meeting. I think we had very thoughtful and productive discussions. I want to particularly recognize Senior Assistant Attorney General Jen Ramsey, who you all know, who is here today. I think she has done an excellent job in really taking the lead in facilitating those discussions. She spent hours with these guys, really trying to find solutions where we can to, again, make this process one that is not perfect. It will not work for every claimant, but I think what you have before you is a process that can work for many claimants, many victims, and give them at least an option that is far more victim-centered and trauma-informed than traditional litigation. I think that's reflected in the letters that you've received from some Claimants Counsel. I think that's also reflected in the indications we've gotten from Claimants Counsel, who, while they haven't submitted a letter, do believe that they have many clients who can use this process. So with that, I'm happy to take any questions.
Are there any questions from the committee? Representative Lynn?
Thank you, Madam Chair. Yes, I first of all, I want to say I think I think you have done an outstanding job in this. I have really no substantive issues, and with regard to the typo kind of things, I mean, that's just it's entirely. It's very easy to see how that kind of thing could happen. And I personally, I don't know about the rest of the committee, I have no problem at all with saying that non-substantive typo correction kind of things should be able to be done. If I could, though, I'd like to ask just a couple of questions. And I refer specifically to FIS 309, which is the guidelines. And in particular, my understanding, I base this question on a discussion I had with Attorney Scolambrini, who I see in the back of the room, and I think you probably discussed it with him also. One of the things that he points out, and I think it's a fair point to make, although I'm not quite sure I'm not suggesting that that changes have to be made. I'm not suggesting that, but I do think it's something that ought to be sort of on the record, so to speak, and something that the administrator ought to take into account, is that in the categorization of the levels of abuse, I'm on page 5 of 309. In the categorization of abuse, and actually I should say maybe it also goes back to page 2. Attorney Scolambrini points out, I think correctly, that there at least arguably could be situations in which sort of a similar level of abuse of a male victim versus a female victim might be treated differently. And what, in particular, what he points out is that in terms of digital abuse of a female, it's almost any touching of female genitalia is very likely to involve some kind of penetration, which would bring it into category A, whereas with a male victim, a touching of, let's just say, a touching of the male penis would not involve penetration, which that would therefore mean that it would be in category C. And depending on the circumstances, there could be, it's easy to imagine situations in which the same sort of level of abuse would be treated differently. I'm not sure there's a good answer to that, but I think it's something that the administrator, ought to take in mind, perhaps in evaluating individual claims. I don't know if you had any comment on that.
Yeah, I think I would agree that is something the administrator could take into account. And to the extent, I don't have any changes that I feel like I could sit here and comfortably say I think would address that would be appropriate. But I would again kind of say that the administrator, once that person is appointed, would have the ability to come back to this committee and request changes, and there may, through further discussion, be something that could be developed on that front. But we did discuss that issue with Attorney Scalambrini, and we were not able to arrive at any changes that we thought could address that issue. But I certainly, the point was taken, and I think it's something that deserves potential future or further consideration.
May I ask one follow-up question? And then the other thing, and it's a little bit different, but somewhat related. You may recall that I had asked a question the last time about whether there was really any difference with regard to, and I'm back on page 2, between category C, intimate sexual touching, parenthesis masturbation, and then D, other touchings. And I think Ms. Ramsey very correctly pointed out that there is a difference in the definitions in the guidelines, and I completely agree with the distinction she's pointed out. But what that doesn't completely address is that there are overlaps between category C and D. In other words, there's some things that could be categorized either as falling into D or falling into C. And I again assume that whether it falls into D or C in some sense would involve the administrator determining how significant was this particular incident of abuse. And is that your understanding also?
Yes, I think that's, yes, I think that's an area where the administrator will just have to make some determinations based on the specific facts of a case.
Thank you. And then, I'm sorry, just the only thing I wanted to point out was just when I saw the typos, if that's okay. So I guess I would say, in terms of, on document 22309, the typos that I think need to be corrected, and no, I'm sorry. Should be on 310. I'm sorry. FIS 22310. I think the typos that need to be corrected are on page 17. In the number 3. It says how old you were you. And I think the last you should go.
I think the first you should go.
Or maybe the first you should go.
Yeah.
And then on page 5 of the worksheet one. Yeah, the worksheet one. Yeah. I think there, it says we're talking about category C, but the lines say right in category A, and it really, in the first line, it should be write the number of incidents of category C. The second line should say write the number of incidents of category D rather than B. The third one, write the number of incidents of category E rather than C. And then the next line down, add incidents of D and E. I think that's right. So
Yes.
that's simple. And I think there was one more that I pointed out to Ms. Ramsey, but just, on page, the next to last page in the notice of filing, again, I think there's just a typo on the second line there where it says, I have filed a claim. The word for is there, but shouldn't be there. I have filed a claim with the administrator, I think. So there's just an extra word there. Other than that, as I say, I think this is, I think you guys have done an extraordinary amount of work, and it looks very good to me, and I plan to vote yes to accept it.
Are there any further questions? Senator Rosenwald?
Thank you, Madam Chair. I do have a few questions. Good morning. Thanks for being back
Morning.
here. First, I'd like to ask how much you expect to pay both the administrator and the private law firm that you've hired out of the fund. I'm wondering how much money will actually be available after those expenses to settle claims.
So the administrator can be a part-time or full-time employee and paid at the same salary or no more than a Superior Court judge, I believe is what the statute says. So if the administrator is full-time, they'll probably be paid around the same salary as a Superior Court judge. If they're part-time, they'll be paid at whatever that same rate would be. So calculate that out to be an hourly rate. They'll be paid around that rate. The judicial branch may need to hire additional staff to help the administrator, which would come out of the fund. So, Superior Court judge, I believe, makes around $170,000, $180,000 a year. Then if you added benefits, I think it would be a few $100,000 for administrator and their staff. I don't expect it to be more than $1 million a year, but probably in the hundreds of thousands per year. And then as far as the outside counsel we've retained for the settlement process, I don't expect that would be more than $1 million a year. It's going to sort of depend on how many claims we get in and what this really looks like as we ramp up. But we have not, I don't expect that we would spend more than $1 million a year on outside assistance. And even that is, I'm not saying that we think it would approach $1 million a year, but to give you an estimate that with some certainty, I just want to be very
So a
conservative.
total of up to $4 million between the administrator and the law firm because it's a 2-year process.
Yes.
Okay. So, thank you. Thank you.
Let me just say one thing on that. It may go longer than 2 years because 2 years is the application process. And so if someone applies in December of 24, that may in fact run a little bit
Another
longer.
year,
Right.
yeah.
Or, some amount of time. So I think that the Attorney General is correct that we're probably looking at 4 million, even though it
It could
may
be more than 2 years.
right.
Okay.
And we'll, of course, try to keep that number as low as we can.
Of course. So the last time you were here, you told us that you had in mind an average maximum award of between $600,000 and $700,000, or in other words, less than 50% of the statutory cap. And that you made the multipliers and aggravating factors work to achieve that. Are you still imagining that average maximum award of $700,000 with your revision, or do you have a new number in mind?
I think what I would say to that is that's always been a very rough calculation. So, when we were going through the legislative process, as part of figuring out what the caps in the legislation would be, we did the research to try to determine an average settlement award amount for similar claims around the country, and that ended up around 700,000. That was just one factor in the original document we submitted to you, is trying to stay roughly within that range, give or take even 100,000 or maybe even a little more. I don't think the changes we've made will fundamentally alter that. But that's also, again, because it was based on some pretty rough calculations and based on only some information about some claimants, it's certainly not an exact science.
Can I continue?
Yes,
you.
you may, please.
Thank you.
Yeah,
So-
go ahead and ask all your questions.
Based on all the information you've reviewed internally, what do you think the median award will be? And what do you think the most frequent award will be?
I apologize, Senator, but I really don't think that's an estimate I can give you, because even the estimates we can give would be based on just looking at, say, a spreadsheet list of numbers of incidents that claimants might allege. But it's really not going to be until we have individuals who tell their stories and really tell us more details about what happened to them, and we have more details about the information they have surrounding what happened to them. It's not going to be until we get that we could start to determine what those numbers might look like. There's still just a lot we don't know. Again, because this is an opportunity to remind everyone of the parallel process we've got going on the criminal side, where we're doing the criminal investigation. We have looked deeply into allegations on the criminal side that are within the statute of limitations and where we think we might be able to bring criminal charges. We have many, many people who would be outside of that statute of limitations, and so we haven't conducted a full criminal investigation, so we just have less details for that population. We also we have some details about some of the claimants on the civil side, less details about others. So there's enough left that we don't know that I'm just not able to give you a good answer to that. These are what we've been able to give so far are very rough estimates when it comes to averages, but when it comes to median and what would be the most common number, it's unfortunately not something I can estimate.
I just wonder, because we need to think how far this $100 million or 96 million is actually going to go. It seems like
Absolutely.
your department would have been able to look at all of the alleged crimes and come up with these numbers based on where you think it's going to land. But in another area, I know that you've changed the frequency multipliers, and it looks, when I see your spreadsheet, that it would take 10 genital, anal, or oral rapes to hit the cap. There's a big jump between 9 and 10 rapes. It's still a lot of rape. And under your new duration multiplier, going from 24 months to 12, victims would hit that cap sooner if the rapes occur over a longer period of time. But even going back 10 years, which was all the information I could get out of the Child Protection Division, the average length of stay for a committed youth was only 7 months. So the shortened duration looks good on paper, but it's not likely to be applicable to the majority of claimants. So I'm really wondering and struggling with why you would award more money to someone who had been repeatedly raped over a longer period of time than over a shorter period of time, because it seems counterintuitive, and I'm wondering what the department's rationale is.
Yeah, I think there's a couple issues in there, so I'm going to try to hit all of them. And if I miss any, please just
Thank you.
feel free to follow up.
Thank you.
The first thing I would just note on the frequency multiplier is that, you know, a claimant could end up hitting the cap with only 5 or 6 of the worst incidents, or even 4 of the worst incidents, because they might also have additional incidents of I hesitate to use the word less severe abuse, but let's just say abuse that falls in a different place on specific facts that a claimant or a victim would bring to this process. So that's just the first thing I would note. You know, you certainly don't have to get to 10 and have a multiplier of 12 to hit the cap, depending on what incidents or what types of abuse you're alleging. We have some information on the average length of stay, I think, which would show that, say, prior to 10 years ago, the average length was a lot higher than 7 months. And I might even ask Senior Assistant Attorney General Ramsey to come up to talk about that a little bit, because I do think we have some of that info. So I do think that longer duration would come into play, given that many of these claimants were from long enough ago when the average length of stay was longer. We've seen that length of stay come down over time. And in recent years, especially the last 10, the average length is a lot lower. But if you start to go back in time, you'd see that the average lengths of stay at YDC were a lot longer than
I
7
hope you
months.
could share that with us, because
Absolutely.
Director Ribson told me that his information only went back to 2011.
Yep, we can absolutely share that. And then on, you know, a higher value for a longer duration, again, there's no what I would say is a correct way to value these things. You know, we try to take into account the research that's available. We take into account our discussions with claimants' counsel. But I think the reasoning for valuing incidents at a higher level, or at least having an aggravating factor if they occur over a longer period of time, is just that I think there's research to show that especially a child, if they suffer, even if they suffer the same incidents of abuse, if that occurs over a longer period of time, so it doesn't occur, say, within 2 months and then it's done, it occurs once, and then it occurs again a couple months later, again a couple months later, again a couple months later, that often is more harmful and causes longer lasting trauma, or a different type and a more significant type of trauma. Again, there's no exact science to this, because every person is different and every victim is impacted differently by the harm they suffer. So I wish I could tell you that we made that change and it would work perfectly and it perfectly fits every single victim. I think on the whole, it's a change that is warranted, because on the whole, if you play this out over an entire population of victims, there is research to show that the trauma is worse if it occurs repeatedly over a longer period of time. So that was the reasoning for that. But I do acknowledge that there's no exact science to this, and that every victim, the harm plays out in different ways for that victim, and the impact is different.
But 12 months is the magic line.
I wouldn't say it's a magic line. I would say it's our best attempt at drawing a line, but I would never sit here and tell you I think that's a magic line.
Thank you. And finally, I share Representative Lynn's concern about the this process and the way it contemplates gender and anatomy. So because boys' anatomy makes it more likely that the assault would be category C for masturbation rather than the anal or genital rape or oral rape. There's so many more boys at the Sununu Center that the A and B awards for boys are less likely to occur, and the higher awards for girls are less likely to occur. But I'm not sure that the victim's experience of trauma is different and matches up with the distinctions on monetary award. And I wonder if you could just comment on that.
I think again the best response I can give to that is, we've just arrived at these distinctions based on the various research that's available and the conversations we've had with all involved. I think, as I said to Representative Lynn, I think there's room for the administrator to take that into account, and there is certainly room for the administrator, who will be an even more objective third-party neutral in this process, to take a look at that, listen to what claimants counsel may have to say on that front, and if the administrator determines that they should come back and request a change to that, the administrator will be able to do that.
Thank you. Thank you, Madam Chair.
Are there any further? Yes, Senator Susie.
Thank you, Madam Chair. Good morning. I
morning.
do apologize. I'm sitting in for Senator D'Alessandro, so I wasn't at the previous meeting, although I did refer to the handouts and certainly have reviewed them. But I did have two questions. One was about your characterization of trauma-informed and a victim-centered process. And I wondered if, in designing the program, you had consulted anyone beyond those advocacy groups or victim advocates that are not employed by your office. Have you gone beyond just the office?
So certainly, as the legislation was going through the process, we consulted with a number of outside advocacy groups. The legislation contemplates really negotiating and discussing this process with claimants counsel and our victim witness advocates within the Department of Justice. I will say our victim witness advocates work with all of these outside groups, and they do an enormous amount of amazing work with all of these groups, and I think they're in a very good position to provide feedback that takes into account the feedback that many of these groups would provide. We also, again, looked at outside research and other sources. We did not, have extensive discussions with outside groups beyond our victim witness advocates, again, because they work with all these groups. They're in a great position to take that type of information into account, and also because that's what was contemplated by the legislation.
Okay, and then I just have one additional question, if I may. And this one is about sort of I think I would view as a challenge, but within the Department of Justice, the role of having to defend the state on the criminal side in these cases, and then also prosecuting on the civil side. And my question is about how you segregate information. So you've gleaned information at this point, I'm sure, through discovery on the criminal side that's informed the process. I'm wondering how you would protect claimant information that might be involved in other cases, even if it's unrelated to this process. And if you've contemplated going forward any segregation for that information of the claimants.
Yep. So within the Department of Justice, we have very strict walls that are in place between the criminal side of this process and the civil side of this process. And generally, obviously, I, as the Attorney General, have access to both, and I try, and it's just a challenge every Attorney General has had to confront over the years. I have to be very disciplined and do my best not to let that information cross the walls. The determination has been made, and it's always been the office's practice, that ultimately the Attorney General is the one who has to make the decisions at the top level and resolve conflicts. So they have to have access to both sides, but the information really is segregated, and neither side has access to the other side's information. The caveat to that is that defendants in a criminal case have have, of course, certain rights to access information that may be exculpatory and relevant to their case. So, you know, I wish I could sit here and tell you that I know exactly how that's going to play out in cases where we've brought criminal charges. I don't know exactly what information may ultimately have to make its way into a criminal case, but we will certainly do everything we can to keep any sensitive information that could cause harm to a claimant if it became public, to keep it private. We'll do everything we can within the confines of a defendant's constitutional rights on the criminal side. At the end of the day, we'll have many, many claimants for whom we cannot bring criminal charges, and so we won't have that dynamic in which there's a criminal case that's relevant to their allegations going on at the same time that they might be either bringing a claim through this process or pursuing their claims in court. But the best answer I can give is that we have strict walls within the department to segregate the information, and that while some of that information may have to cross over in a criminal case based on the requirements that exculpatory information be provided to a criminal defendant, we'll do everything we possibly can to keep sensitive information private.
And could I just ask one follow-up to that
Certainly.
point, General Formella? Would you see a scenario where perhaps the administrator, once appointed and into their responsibilities, might come before this committee or recommend additional legislation to try to further ensure privacy for claimants so that that line is a little bit brighter?
Sure, I could envision that, especially as this process begins to get set up and implemented and the administrator gets their arms around it. That could be the type of thing the administrator comes back to this committee or brings forward recommendations to the legislature on.
Thank you.
Or this committee requests his presence or her presence.
Right.
I don't want to make an assumption. Representative Edwards, you had a question.
Thank you, Madam Chair. And I'm gonna basically leapfrog off of what Senator Susi just said, and take this in a little bit different direction than the rest of the questions have been. But as I look at section 310, the document 310, page 6, at the bottom of that, there's a very nice, concise executive summary of the legal notice dash privacy and confidentiality. And I view this write-up as being necessary, but perhaps not sufficient. And so I'm curious, particularly listening to the response to Senator Susi's questions about the sharing of information within the department, whether or not there should be an explicit written privacy policy, which is the way we did it in the corporate world. We would write a privacy policy that was probably multiple pages in length. And one of the things that we would touch upon in a privacy policy is the extent to which sharing of the data within the company between third-party agencies could be done or had to be protected and stopped, right? So there's a sharing component of it that I think Senator Susi has touched on. Then there are two other parts that just jump out at me as things that you might find in a privacy policy. One would be the individual who's filed a claim. What rights do they have to request the termination of their claim and the deletion and destruction of any information that they had provided to the state? It's basically, in Europe, it's referred to as the right to be forgotten. And I'm just curious if we've anticipated that we might ever have a claimant want to just withdraw and have any state knowledge of what they've provided destroyed. So that's the second aspect. And then the third, typically in a privacy policy, it'll state specifically what a retention period might be. How long will this information be retained by the state? 10 years after the settlement, 20 years after the settlement. At some point, we should be able to put a stake in the ground and say, after this date, this is the type of information that shall be destroyed. Now, certainly, there's probably always going to be some component of the information that needs to be retained, but parts of it that can be expunged and destroyed ought to be, as a matter of programmatic policy. So again, I want to come back and I want to say this is a really nice executive summary of the privacy and confidentiality limits or rules of engagement. And I'm just curious the extent that there's maybe a supplemental privacy policy that's broader and deeper than what this does.
So I think to the extent that we're talking about, the sharing of information within the Department of Justice, we have very routine just sort of procedures on how we handle that when someone is.
Okay, I just, in the interest of time, I just want to keep the question simpler, which is, do you see that there's a need for another document around the privacy issues that are broader and deeper than this statement on page 6? It's kind of more of a yes or no, and then there's plenty of time to talk details, but
Yes, I think there certainly could be room for that. I would just note, without taking up too much time, I promise, that we discussed this in the legislative process, and I know there was a balance between the need to maintain privacy and also maintain generally the access to records of all of this that the public may have an interest in. And I think this is based on that balance we ultimately arrived at the legislation. But I think, yes, this will warrant further and I think continuing conversation as this process plays out as to whether we need to beef this up.
Representative Wallner?
Thank you. Mr. Attorney General, while I was sitting here, we received a letter from Commissioner Hanks. And in her letter, I've been trying to skim it really quickly. In her letter, she brings up a couple of concerns. One about that they, at the prison, they cannot use internet for filing these claims. And the other being around the phone system used by the residents at the prisons, and that they would only be able to make collect calls. And I wondered if you had discussed with her how you will proceed with those two issues.
Yes, so the collect calls piece, I think we can certainly work with the administrator on that to and charge the administrator with working with the Department of Corrections to facilitate a resident's ability to make calls to the administrator. So I think we certainly we can work with both the administrator and the Department of Corrections on that. On the access to the internet piece, I think I mentioned earlier in my remarks, I'm not sure there's a way to alter that policy on residents not having access to the internet, but we certainly are willing to and will discuss with the Department of Corrections, discuss with the administrator once that person is appointed, whether there's some other way to enable a resident to interact with this process electronically. I don't know if there will be, but if there is a way to do it that doesn't raise concerns with the Department of Corrections and that is possible, we'll certainly do it. So I'm committed to working on that.
Thank you.
Yes, go ahead.
Thank you. I wondered if Commissioner Hanks would want to say anything about these two areas of concern or any other areas of concern.
I don't know if it's morning, so maybe good afternoon or good morning. Thank you for that opportunity. For the record, Helen Hanks, Commissioner of the Department of Corrections, and thank you for those two specific questions. The internet will be a challenge because of our requirement to meet what's called CJIS, Criminal Justice Information System requirements, and not allowing people who are incarcerated onto our internet. We do not have a separate resident network. And then we have a significant number of individuals incarcerated for sexual offenses who have computer access prohibited as part of their sentencing document. We can find a path forward, I'm sure. I'm not sure it will be through the internet. And we do have individuals who obviously are filing claims on a daily basis, and we do have notaries, and we are still helping them process paper. And so that is the fastest, most efficient way. But to ask correctional staff, for example, to then be a steward to file e-claims would put, I think, both the claimant and the employee in an awkward situation. So I do think access to the internet will be a challenge. If there was a hypothetical conversation around a legal liaison, we could set up an office space and give that person as a steward to the administrator access to the internet. But we want to make sure that the person facilitating internet access has control of the internet and is an impartial third party to the process. So that's the first response I would make with regard to the internet. The phone system, been trying to contemplate a solution to that, because certainly we do not want to create an impediment to contacting the administrator. And as we allow individuals to have attorney calls, I'm working with our current vendor on what that might look like to create a, here is the phone number, here's a point-to-point access on the phone system that does not allow for a charge on either party. So I think that is something that we can overcome and establish a plan with the DOJ and the administrator on that point. So I hope that provides some additional information. And certainly I'm willing to answer any other questions or follow-up.
Senator Rosenbaum, you have a question
I
for
do.
Commissioner
Thank
Hanks?
you, Commissioner Hanks or General Formella. Have you had discussion with the county houses of corrections to see if they would have the same good access to notaries and telephones, even collect as the state facilities?
Senator Rosendahl, certainly I have not. I know some information about who have similar systems and who do not, but I would refer to General Famella on that.
We have not, but we could certainly do that.
Thank you, Senator Rosenwald. That was one of my questions as well. Because, yeah, we did not discuss at all the county correctional facilities. And I think that we need to make sure that that's included. Okay, I do have two questions besides that one. First of all, I noticed that you are identifying One Granite Place as the place for the administrator. Are you going to be in that building by then, or is the administrator going to live there all by him or herself?
Well, I think right now the courts are over there.
Okay.
So that, yeah. So I don't know if we'll be in there by then, but we'll be in there eventually. But given that the administrative office of the courts is over there, that's why the administrator is going to be there, because they're working in the judicial branch.
Okay, fine. That was good news to me, actually. Thank you. And my other question is that we had talked about putting the claim form up on the web with a fill in the blank kind of thing. Is that progressing?
It will be progressing. Yes.
Okay.
We've had discussions with the court system about that.
Okay, so you're hoping to have that done by the 1st of December or before?
Yeah, certainly, I think January 1 is when the claims window opens. So certainly by the time the claims window opens on January 1, yes.
Okay. All right. Okay. Seeing no further questions, I would entertain a motion to approve FIS 307, 308, 309, 310, and add the comment that the AG can correct typos in the document without coming back to the Fiscal Committee. Thank you.
Second.
Madam Chair,
Yes.
to that motion about correcting the typos, it would seem prudent that they should either get reviewed by the chair or approved by the chair as a matter of course, just so that there is a connection with this committee. I was wondering if that modification to the motion can be made.
It certainly
and a
can.
decision made between approval or notification.
Okay, I have no problem with that. I love this document. I've read it so many times. I obviously can't see typos in it, so. Is there any further discussion? Senator Bradley.
Thank you very much, Madam Chair. I think that this is a very reasonable way to move forward. I appreciate in particular the changes to the multiplier, as I think that really solidifies the process and the document. I think it's also important, and we haven't really discussed the letters that we've received, but going back to when Representative Umberger filed the legislation, I don't think it ever was envisioned that this was going to work for absolutely everybody, that there were still some claims that were going to go forward through the court system. And so I go back to the letters that we've received, and I think it bears note that the letters talk about the fact that and these are from the attorneys that represent some of the claimants, that some of the issues have been resolved by the process. And so that's, you know, obviously to your credit and to the credit of the attorneys, some of whom are here today. But they also talk about that it's a fair way, and I'm going from Tony Scalambrini's letter, a fair way to resolve liability for many, but not all of the children that were abused by the state authority. That is consistent, I think, with the process that was outlined in the legislature. And then also Mr. Rainbow's letter says something very similar. We strongly believe that if the administered is efficiently and equitably, a large majority of the claimants will strongly favor the program for two main factors, time and process. So I think while no legislation, this included, is ever perfect for everybody, it's a very reasonable way of proceeding. I think it's also important that we've heard from not only yourself, but in the conversations that you've had with some of the claimant attorneys, a process for choosing the administrator. That's going to be very important. And I think the commitment that's been made today that the administrator can come forward either to the Fiscal Committee or potentially even the full legislature with possible changes based on, you know, what happens, I think is also effective. So I think, you know, you've done a really good job. I think, you know, I want to give a shout out to Tony Scalambrini and a couple of the other attorneys that worked long and hard with your office, with Ms. Ramsey. So I think it's a reasonable way to proceed and hopefully bring closure for a number of people that just having to rely on the court system is not going to work for them because of what was outlined in terms of time and process. So I am pleased to second Senator Daniels' motion.
Okay, I think you have to third it because
Oh, okay.
Representative Lynn, I think. I heard that in my ear, but that's okay. Okay, are there any further discussion? Seeing none, will the clerk call the roll?
Emmerich votes yes. Representative Erf.
Yes.
Representative Lynn.
Yes.
Representative Wallner. Representative Daniels.
Yes.
Representative Senator Bradley.
Yes.
Senator Gray.
Yes.
Senator Rosenwald.
No.
Senator Susie.
No.
Representative Umberger.
Yes.
Madam Chair, the vote is 7 yes, 3 no.
With the vote of 7 in favor and 3 opposed, FIS 307, 8, 9, and 10 pass. So, I would like to just say that I know, and I think we all know that if we had a million years to try to get this process absolutely perfect, we might make it. We've had roughly 3 months. And I do want to stress that the person that is appointed as administrator will relook at this, see if there are things that he or she thinks need to be adjusted, and we're open at any time on the Fiscal Committee for the administrator to return. But I truly thank the AG's office for all of the hard work, and both in preparing the legislation as well as preparing the process. And I know that you and Jennifer have spent untold hours in trying to get this to the point where it is today. So I truly thank you, and I guess that as far as people in YDC that have been abused, this is another step forward without spending time and money trying to go through the court. And as I think we all understand, if the people go through the court, we're looking at probably years and years before that process can be completed. But for those that feel very strongly that this this alternative process is not going to work for them, then yes, they should in fact go to court. But I thank you, and I thank all of the folks on the Fiscal Committee, and I will see you Friday for our,
You're going to see us,
yeah,
some of us have pre-fiscal. I don't
yeah,
know.
for our regular Fiscal Committee meeting. And I know that General Formella will be back, and I know that Commissioner Hanks will be back. So I look forward to seeing you all on Friday. And Fiscal is adjourned.
Thank you.